In late April 2024, the Committee of Ministers of the Council of Europe instructed the Secretary General to prepare documents for the conclusion of an agreement with Ukraine to establish a special tribunal for the crime of aggression. This is a long-awaited and highly welcome step for Ukraine. While the Council of Europe might currently be the most effective avenue for establishing this tribunal, a major hurdle for such an avenue is immunities. Overcoming the immunity of high-ranking Russian officials is a significant challenge. This is because there is no well-established legal norm or state practice that supports the conclusion that immunity can be overcome in tribunals established outside the United Nations framework. This is Cindy Abata, and in this video, I will talk about the feasibility of establishing a crime of aggression tribunal for Ukraine under the auspices of the Council of Europe. Russian invasion of Ukraine has led to a wide variety of crimes and legal questions that require innovative approaches. While the International Criminal Court and different domestic courts are investigating and prosecuting Russian war crimes, crimes against humanity, and genocide, the crime that caused all the other atrocities, the crime of aggression, is being left unaddressed due to jurisdiction and immunity challenges. Ukraine believes there won't be any peace without accountability for the crime of aggression. Since the February 2022 Russia's invasion of Ukraine, academics and legal professionals have issued several proposals for the establishment of a crime of aggression tribunal for Ukraine. These proposals have tried to overcome the jurisdictional challenges that domestic courts and the ICC face with regards to the investigation and prosecution of the crime of aggression. Among these is the proposal for the establishment of this tribunal under the European mechanisms. In a memorandum published in June 2023, PILPG analyzes the legal options for the tribunal to be set up under the auspices of the Council of Europe. With the recent developments, the Council of Europe option might be the one that leads to tangible results. But will it be feasible for prosecuting the Russian leadership? High-ranking Russian officials such as Vladimir Putin and Sergei Lavrov, being respectively head of state and foreign affairs minister, are in principle protected from prosecution under immunity principles. Yet, the International Court of Justice and the International Criminal Court have essentially reached a consensus that these immunities do not apply before certain international tribunals. What constitutes an international tribunal thus far has not been clearly defined. A joint concurring opinion of an International Criminal Court's judgment on the arrest warrant issued for the former Sudanese president shed some light on the question. The opinion noted that an international court may be regional or universal in orientation. However, it has to be established through a mandate of an international body such as the UN. Similarly, the Special Court for Sierra Leone dismissed an immunity defense by the Liberian president, Charles Taylor, emphasizing that the court was established through an agreement between the United Nations and Sierra Leone, and therefore an expression of the will of the international community. Now, what then is an expression of the will of the international community? It is broadly accepted that the International Criminal Court constitutes an international tribunal. Article 27 of the court's statute clearly established that the states parties to the ICC have waived their right to immunity. But the immunity waiver extends beyond the member states of the ICC to nationals of third states over which the ICC has lawfully exercised jurisdiction, as was done in the Sudan situation. Pursuant to the terms of the Rome Statute, the ICC became operative following the deposit of the 60th ratification and accession. Accordingly, some scholars have proposed that a joint effort of 60 states is sufficient to establish a court of an international character, which expresses the will of the international community. Moreover, the ICJ referred to the ICC as an international tribunal able to overcome the immunity defense at the time when there were only 52 states parties to the Rome Statute. What does it mean for the efforts to create a crime of aggression tribunal under the auspices of the Council of Europe? The Council of Europe has 46 member states, which would not reach the 60-state effort threshold. Moreover, the regional focus of the Council of Europe may become a challenge for representing the internationality of the court. Scholars have therefore proposed that for the crime of aggression tribunal established under the auspices of the Council of Europe to reach the character of an international tribunal, the agreement should be open for signature by all states, not limited to those part of the Council of Europe. And this agreement should reach at least 60 ratifications to be considered an expression of the will of the international community. In conclusion, the establishment of the crime of aggression tribunal through the Council of Europe could have political benefits, such as the existence of widespread support across the region. At the same time, however, it could encounter many legal challenges related to immunity. To read the full PILPG analysis, find the link below.